Good morning to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Sharvil Majmudar sir, and to all the participants in this fifth day of 10 days online national capacity building program for civil judges examination of Gujarat State Judiciary, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, former Judge of Supreme Court of India and Patron of Sambhav Initiative. Honorable Mr. Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Gujarat High Court Advocates Association, which is a voluntary organization formed by Association of Advocates regularly and ordinarily practicing in the Gujarat High Court with the purpose to promote professional goals, objects, and interests of advocate members in general, and is led by a managing committee which shall have total 15 elected members. It holds legal seminars and study circles to keep the member advocates updated with the current legal developments and Advocates Care Society, where today's session is all about overview of the Code of Civil Procedure 1908. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or raise your hands. It is my privilege to introduce our esteemed dignitary, Sharvil Majmudar sir. With over 2 decades of legal practice at the High Court of Gujarat, Sir brings extensive experience in handling a wide range of matters, including land laws, Indian Contract Act, and arbitration. Sir has successfully conducted numerous arbitration proceedings, both domestic and international, and is frequently invited to speak at the conferences on arbitration and related legal topics. His deep expertise and practical insights make Sir a respected voice in the field of dispute resolution. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you very much. First of all, I would like to thank Sambhav for giving this opportunity to me. So the topic assigned to me is overview of Civil Procedure Code. Now, Civil Procedure Code is like an ocean. So within 90 minutes, I will try to touch on the main relevant provisions of CPC, which we usually deal with in day-to-day matters or in litigation in courts. Because otherwise, CPC consists of 158 sections and 51 orders, which are also sometimes referred to as schedules. So the sections are the substantive provisions and the orders are the procedural provisions. So we should first understand that Code of Civil Procedure is basically a code to regulate procedure in a civil trial. So these are all procedural provisions, but they are very important because lot of time issues arise and dispute arise as to breach of particular procedural provision. So we must understand, and I'll take you to the relevant provisions of CPC which we usually come across in day-to-day matters. So the first provision which I would like to take you to is Section 9 of Civil Procedure Code. Section 9 of Civil Procedure Code says that civil courts will have jurisdiction to try all kinds of suits except suits which are impliedly or expressly barred. So this means that for any civil dispute, civil court will have jurisdiction unless the suit is expressly barred, meaning that it is barred under some provision of law, or it is impliedly barred, meaning that there may not be an express prohibition of law, but impliedly it is barred. So express bar we can find in many laws. For example, if you see the provisions of Securitization Act, there is an express bar under the act that no civil suit shall be filed. The dispute between bank and borrower has to be decided by the debt recovery tribunal only. So that is an express bar to a civil suit under a statutory provision. Implied bar are cases like land acquisition matters or cases with regard to labor disputes, where under the respective Land Acquisition Act or Industrial Dispute Act, we may not find an express bar to filing of a civil suit. But considering the inherent provisions of those acts, there is an implied bar. So there is a separate mechanism provided in those concerned respective acts to resolve those disputes under those acts. So there is an implied bar. So bearing these two situations where there is an express bar or an implied bar, civil court will have jurisdiction to try all civil suits. So this is contained in section 9 of CPC. I have just given you some examples of implied bar and express bar. There are obviously number of situations and number of cases where there will be an express bar or there will be an implied bar, and many times issues arise before the court whether this civil suit is maintainable or not. So for that, section 9 says that all civil suits are maintainable. Civil court will have jurisdiction to try all suits unless expressly barred or impliedly barred. The next provision which is of some significance is section 10 of Civil Procedure Code. So section 10 of Civil Procedure Code says that if parties have filed one suit and subject matter of dispute is already pending adjudication of that suit, then a subsequent suit between same parties arising from the same cause of action shall not be proceeded till the first suit is decided. So sometimes let me give you an example of section 10, that sometimes it may happen that a person has an agreement to sell in his favor. He goes to the court and files a suit for specific performance. That suit is pending. During the pendency of that suit, the defendant executes a sale deed. The plaintiff therefore files a second suit to set aside the sale deed. So his first suit with regard to specific performance of agreement to sale is pending. During the pendency of that suit, sale deed is executed, so he files a second suit. Since the second suit is arising between same parties or parties claiming through the same defendants and arising for the same property, the second suit will have to be stayed till the first suit is disposed of. So that is the logic of section 10. However, courts have interpreted that even when the second suit has to be stayed while considering section 10 of Civil Procedure Code, interim orders can be passed in the second suit. In the second suit, if the plaintiff has prayed for injunction orders, then such interim injunction orders can still be passed in the second suit, even if the second suit is to be stayed pending adjudication of the first suit. The next relevant provision I feel is section 11 of Civil Procedure Code, which is the principle of res judicata. So many times, friends, you would have noticed lawyers arguing that this is barred by res judicata. So what is that res judicata? Res judicata is found in section 11 of Civil Procedure Code. It is a concept found in public policy basically, and it plainly says that no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim. So it in plain language, if I can explain, res judicata means that if there is one suit between A and B, which is already decided, and some of the issues in the said suit are already decided, then a subsequent suit between the same parties or between parties claiming through them will not be maintainable because that issue has already been decided in an earlier suit. So if an issue is already decided in an earlier suit and the same issue arises in the subsequent suit between same parties or parties claiming under them, then that issue would be res judicata as far as the parties are concerned. Because this is also a concept of public policy, because you cannot allow parties to raise the same issues again and again. If the court has already decided an issue, then that issue will operate as res judicata between that parties. So the difference between section 10 and section 11 is that section 10 of CPC speaks with regard to stay of the subsequent suit, and section 11 says that if an issue is decided, then that issue cannot be decided in a later suit. It will operate as res judicata. So this is the difference between section 10 and 11. I'm just referring to it broadly. The next relevant section I feel is section 16 of Civil Procedure Code, which says where the suits should be instituted. So section 16 of Civil Procedure Code is basically a section with regard to territorial jurisdiction of civil courts. So friends, we should all keep in mind that the civil courts, there are certain limits on jurisdiction of civil courts. One limit is with regard to the territorial jurisdiction. Then we have limits with regard to the pecuniary jurisdiction, that is the monetary valuation where the suits are to be filed. Some suits, as per the Civil Courts Act and Court Fees Act, are to be filed before the Civil Judge Junior Division. Some suits are to be filed before Civil Judge Senior Division. Some suits like trademark, etc., are to be filed before the Learned District Court. And in some cases, even the Honorable High Court has original jurisdiction to try certain suits. So I was dealing with section 16 of Civil Procedure Code, which says that where the suit should be instituted. It says that suits should be instituted where subject matter of the property is situated. So there can be a case where the suit is with regard to different properties. For example, there can be a suit where the subject matter of property is situated in territorial jurisdiction of Ahmedabad, and for another property, the subject matter of the suit could be in Vadodara. So in such a situation, you can file a suit in any of the courts. The properties are more and are situated in territorial jurisdiction of different courts. All courts would have, where the properties are there, would have jurisdiction to try the suit. Also, the important point is that if the defendant is objecting to the jurisdiction of the court, then the defendant should raise that objection immediately. He cannot submit to the jurisdiction of the court and at the fag end of the trial raise an objection with regard to jurisdiction. He should raise it immediately, and then the civil court can decide whether it will have territorial jurisdiction or not. The next provision, if we go ahead, as you are all aware that, as I said, that there are certain orders in Civil Procedure Code, and then there are certain sections. The sections deal with the substantive provisions, and the orders more or less deal with the procedural provision. So I'll just briefly discuss relevant sections further. One is section 47, which is with regard to execution of decrees, and it says that the executing court will have to decide all questions arising out of the execution of decree. And for those issues which arise out of execution of decree, a separate civil suit is not maintainable. So section 47 in fact bars a separate suit to be filed for questions arising out of execution of decree. So execution of decree will start once the suit is already adjudicated, decree is passed, then the plaintiff goes for execution. So where a question arises whether any person is or is not a representative of a party, such question will have to be determined by the executing court, and all incidental issues will have to be decided by the executing court. What is to be kept in mind is that the executing court cannot go beyond the decree. The decree has provided something. The executing court cannot add anything to the decree. This is a fundamental principle. The executing court has to execute the decree as it is. The corresponding procedural provision to order to section 47 is order 21, which I'll take you later when I deal with the orders. But this is a substantive provision. Section 47 is a substantive provision with regard to execution of decrees by the executing court. And the Honorable Supreme Court now in few matters has also given directions to the executing court that the decrees should be executed not later than 6 months, because in number of cases the defendants keep on raising objections with regard to execution of decrees, etc. And execution of decrees take time. So we have now directions of the Honorable Supreme Court where the Supreme Court has said that the executing court should proceed with execution applications expeditiously because the plaintiff should not be deprived of the fruits of the decree. Because whenever a person loses in a suit, he will try to raise all kinds of objections to see that the plaintiff is unable to execute the decree. So such a situation should be avoided, and it is the executing court's duty to see that frivolous objections to executions are not entertained, the execution is proceeded fast, and that the plaintiff gets the fruits of the decree as soon as possible. The next relevant provision which we often come across is section 96 of Civil Procedure Code, which is the provision with regard to the first appeal. So this is a very important provision. So whenever a party files a suit and an order is passed, the aggrieved side can file a first appeal. That first appeal provision is section 96 of Civil Procedure Code. The corresponding procedural provision is order 41 of Civil Procedure Code. Now, why section 96 is important? Because first appeal is a very valuable right of an aggrieved party. The courts have taken a view that the appellate court, first appellate court, is virtually assigned a duty to reappreciate the whole evidence. It is just like continuation of the suit. So the first appellate court can reconsider the entire evidence. It can reconsider the documentary evidence. It can reappreciate the oral evidence, the deposition of parties, and it can come to its own view. The first appellate court would be failing in its duty if it merely says that it agrees with the judgment of the trial court. That is not the job of the first appellate court. The first appellate court has to analyze everything independently afresh, and thereafter it can either agree or disagree with the judgment of the trial. But the first appellate court, therefore, also will have to frame points for determination, just like trial court has to frame issues. The first appellate court has to frame points for determination, and it has to deal with each aspect of the matter independently and come to its own separate finding. So that is the duty of the first appellate court. Then we have section 100 of Civil Procedure Code, which is with regard to second appeal. So after the order of trial court, we have first appeal. And after the first appeal is decided, the aggrieved party will have a right to file second appeal. Second appeal will lie to the Honorable High Court only. And second appeal is or can be entertained only on a substantial question of law. So the difference between powers of the first appellate court and the powers of the Honorable Court in second appeal are that while the first appellate court can reappreciate the entire evidence, in second appeal, the Honorable Court would not go into facts. It would only examine whether there is a substantial error of law in the orders of the court's being. If the Honorable High Court finds that there is a substantial error of law, then a substantial question of law will be framed, and that substantial question of law will have to be answered by the Honorable Court. So second appeal, friends, is restricted only on a substantial question of law, and the second appellate court would not therefore go into detailed analysis of the facts of the case. And the Honorable Supreme Court has said that in second appeal, the courts will have to frame a question of law before the second appeal is allowed, and without framing a question of law, substantial question of law, the second appeal cannot be considered. And therefore, the words used is kindly marked, it is substantial question of law, not merely a question of law. So a question of law of substantial nature has to arise in the matter for the courts to exercise powers under section 100 with regard to second appeal. The courts have taken a view that even wrong interpretation of a document is a substantial question of law. Misreading of evidence is a substantial question of law. So there are a number of cases where the courts have said what can be considered as a substantial question of law and what cannot be considered as a substantial evasion. So all these arise in section 100 of Civil Procedure Code. The next relevant section with regard to powers of the court is section 114 of Civil Procedure Code, which is the power of review. So, what is review? Review is that when a person applies to the same court, saying that there is an error apparent on the face of the order or the face of the record, which is required to be corrected. So that is the power of review or the provision of review. It is section 114 of Civil Procedure Code. So if a party is aggrieved by an order, it has to file a first appeal, thereafter second appeal. But if the aggrieved party feels that in the judgment itself there is an error which is so apparent, on the record it is very apparent, then it can file a review under section 114 of the Civil Procedure Code. The important thing to be kept in mind is that review cannot be filed if you have already availed the remedy of appeal. So if you have filed an appeal, you cannot file a review. Section 114 very clearly says that subject to the aforesaid, any person considering himself aggrieved by a decree or order from which appeal is allowed by the court but from which appeal has not been preferred can file a review. So if you file an appeal, then just you forget about the review, concentrate on the appeal. But if the aggrieved party feels that there is an error apparent on face of the order or the record, the aggrieved party can certainly file a review and point out that, sir, there is an error on the face of the order, and the court can consider the powers under section 114 and exercise jurisdiction of review and correct that error. However, the courts have now interpreted that subsequent change of law is not a ground of review. Also, if fresh material is available, that is also not a ground for review. So review has to be on the basis of an error which is there on record, which is palpable on the basis of material on record. Only then the exercise of review jurisdiction is available to the court. The next provision is section 115 of CPC, which is the power of revision. That power is available with the Honorable High Court, and it says that High Court in a given case can call for record and proceedings of the subordinate court and can revise any order made by the subordinate court. However, by an amendment in 2002 in CPC, it has been now provided that revisional jurisdiction is available only in cases where if the application of that concerned person was allowed, the suit would have been disposed of. And only in such cases, the revisional jurisdiction is available. So meaning thereby, very plainly put, that against interim orders, revisional jurisdiction is not available before the Honorable High Court. It is only available in cases where if the application was allowed, the suit would have been disposed of. For example, if the defendant has filed an Order 7 Rule 11 application for rejection of plaint and that application is dismissed, then against that order, civil revision application under section 115 of CPC would be maintainable. But if the plaintiff has applied for an injunction and he is lost in injunction application, then again that order, civil division application will not be maintainable because allowing that matter will not finally dispose of the suit. Allowing the matter with regard to Order 7 Rule 11 application will finally dispose of the suit. So in such cases, the jurisdiction of High Court under section 115 of Civil Procedure Code is available. Friends, now let us go to one important provision of CPC, which is section 144. So section 144 of CPC is the provision with regard to restitution. So restitution arises in a case where a decree or judgment is reversed and the court wants to restore the same situation, then under section 144 of Civil Procedure Code, the person has to make an application to the court, the trial court, and the trial court will order restitution. So let me give you an example. Take for example, there is a dispute between landlord and tenant. The landlord has filed a suit against the tenant for taking back possession. That suit of the landlord is allowed. The tenant files an appeal, goes to the appellate court. However, since there is no stay, the landlord executes the decree, files execution application under section 47 as I just referred earlier, and the executing court passes an order directing the landlord to take possession. So during pendency of the first appeal, possession is taken by the landlord. However, after some time, the first appeal is allowed by the appellate court and the order of the trial court is set aside. And the appellate court holds that that the order of the trial court granting decree of possession was illegal. What happens in that situation? The order of the trial court in favor of the landlord is set aside. However, the possession is taken by the landlord on the strength of that order. So that is taken care of in section 144 of CPC. It provides for restoration of the situation as if there was no such order of the trial. Because if a party acts on the basis of an order and subsequently that order is found to be illegal, then the party cannot be allowed to retain the benefits of that illegal order. So that is the principle of restitution for which an application may have to be made to the trial court, and the same position will be restored by the trial court, restored back by the trial court as if there was no such order which has been set aside. That is an important principle which may come arise in practical situations. And then there is one relevant section, section 151 of the Civil Procedure Code, which is the inherent powers of the courts to pass orders for the ends of justice. So, in Criminal Procedure Code, you have section 482, which is inherent powers of the criminal code. In Civil Procedure Code, you have section 151, which is inherent powers of the civil code to do and to pass any orders to meet the ends of justice. So, whenever a situation arises which is not provided in the code, civil procedure code, then the civil court can take recourse to section 151 of CPC and pass orders with regard to uh, doing justice or in order to meet the ends of justice. However, this power has to be exercised in a circumspect manner because Honorable Supreme Court has said that if there is an express provision in the statute in the Civil Procedure Code, then the court cannot take recourse to section 151 and pass orders under the guise that to meet the ends of justice, the court is passing the orders. That is not the purpose of section 151. Section 151 only applies in a situation where there is no provision in regard to with regard to civil procedure code and the court is required to pass some orders. In that situation, section 151 can be taken recourse to and orders can be passed. So these are the main substantive provisions of civil procedure code, sections of civil procedure code. However, as I said earlier, civil procedure code contains several orders, and those orders are actually more important and have and enshrine the procedure in detail. So while we have an overview of civil procedure code, we have to understand the provisions of various orders of civil procedure code because they are ultimately the lifeline of civil procedure code and they deal with the day-to-day situation which arise before the courts. So let us start with the first relevant order, which is Order 1 Rule 10 of Civil Procedure Code. So what is Order 1 Rule 10? Order 1 Rule 10 says that the court 10 subsection 2 in particular says that the trial court or any court has a power to add a necessary or a proper party or to delete a party which is not necessary or proper. Dear friends, we have number of litigations pertaining to whether a person can be termed as a necessary party or a proper party. This is a very relevant provision and it arises in day-to-day adjudication of matters, not only before the trial court, but before the district court, honorable high court and honorable Supreme Court. So we have reported judgments of honorable Supreme Court also as to who can be termed as a necessary party and a proper party. So the law is that if a plaintiff does not join a necessary party, then it is fatal to his case. However, parties can be added at any stage of the suit. So if a plaintiff has filed the suit initially and has not joined a necessary party, at subsequent stage, he can still add that party. Now, whether that party is a necessary party or a proper party will depend on the facts of the case. But ultimately, if the plaintiff wants to join somebody saying or making an averment that that party is a necessary party or a proper party, ordinarily the court would allow that application of the plaintiff because the plaintiff is the dominus litis. The plaintiff is the captain of his own suit. The court will not allow such an application only if it finds that such party is unconnected with the dispute. It has got no semblance of interest in the dispute, and in such cases, such party may not be added by them. So, for example, take a situation again. I may give you an example of a suit of specific performance of an agreement to sell filed by the plaintiff. In that suit, during the pendency of the suit, the defendant transfers the property. So the purchaser will be a necessary party. So the plaintiff, instead of filing a separate suit to cancel the sale deed, the plaintiff can file an application under Order 1 Rule 10 and seek the liberty of the court to add the third party purchaser as a party in that suit. And that party would ordinarily be added in the suit as a necessary and proper party. So that power is available to the court under Order 1 Rule 10 of Civil Procedure Code. And there are large number of judgments, as I said, as to who is a necessary party, who is a proper party. So a party in whose absence effective adjudication of the suit cannot be done is a necessary party. And party whose presence is not required for adjudication of the dispute is not a necessary party. This is just fundamental principle. The next relevant order is, and a very important one at that, is Order 6 of Civil Procedure Code. So Order 6 contains the procedure or law with regard to pleadings. This is, in my view, this is the most important part of the Civil Procedure Code. So what are pleadings? Pleadings means plaint as well as written statement. So plaint and written statement generally are considered to be pleadings. So Order 6 says what has to be pleaded in plaint, what has to be pleaded in written statement. There are further provisions like Order 7, Order 8 also. Important provision is Order 6 Rule 4 of Civil Procedure Code, which says that if a person in his case is relying on is saying that there has been a fraud or misrepresentation or cheating, etc., on undue influence, then particulars of such fraud have to be specifically pleaded as to when such fraud occurred, when did the person came to know of such fraud. A party cannot just merely say that this action is fraudulent. The party has to plead as to how did that fraud occur, when did that fraud come to his knowledge, when did it surface on record, and in what manner has the fraudulent activity affected the transaction, etc. So specific particulars of fraud have to be given. General particulars of fraud are not enough, and that provision is contained in Order 6 Rule 4 CPC. Very important provision is Order 6 Rule 17 of CPC, on which there has been large number of litigations. Matters have gone up to Honorable High Court, Honorable Supreme Court. And Order 6 Rule 17 is with regard to amendment of pleadings, as to when a party can amend the plaint or written statement. So Order 6 Rule 17 says that at any stage of the proceedings, amendment in pleadings can be made. However, it says that if the trial has already commenced, then amendment in pleadings cannot be made unless the person says that despite due diligence, he or she was not able to file this amendment of pleadings before the trial commenced. So let me explain this by an example. That a person has filed a suit Thereafter, issues are framed, examination in chief has been given, and after that, if a person wants to file an application for amendment in pleadings, then he has to show that despite due diligence, he was unable to bring this amendment on record before the trial commences. So trial would ordinarily commence when the issues are framed and when the evidence starts. That is the examination in chief is standard. That is the date usually when the trial commences. So before that, if you file an amendment application, ordinarily you can file. There is no bar. However, if it is filed after the evidence has started, then you have to specifically plead why you could not file this application for amendment despite due diligence. So in many cases, there could be a subsequent event which has taken place or a subsequent development which has taken place after the trial has commenced. So the concerned plaintiff or defendant can say that though I'm filing this amendment after the trial has commenced, but this is with regard to subsequent event or a subsequent development. So please permit such an amendment. So in such cases, such amendments can be considered by the court. Now there are a number of judgments on this, as I said. The courts have laid down the principle that any amendment which changes the entire nature of the suit should not be permitted. For example, if you have filed a suit saying that you are owner by adverse possession, you cannot then subsequently file an amendment application saying that now by virtue of an agreement to sale also I have rights over the land in question, because that is changing the whole nature of the suit. So a rent suit cannot be changed into a suit for title by filing an amendment application. So any amendment application which changes the nature of the suit should not be allowed. Ordinarily, the amendment should be liberally considered by the courts, because granting of amendment will allow the courts to curtail multiplicity of proceedings. If a party can file a fresh suit on the same cause of action, the courts would ordinarily say that in order to avoid multiplicity of proceedings, the amendment is allowed. Also, this rule of due diligence, which I said, that after trial, you cannot file amendment application unless you plead due diligence. That provision came in CPC in 2002. In 2002, there were major amendments made in CPC, and most of these amendments were made in order to see that the trials are disposed of expeditiously, because expeditious disposal of trial is always a challenge considering the due process which has to be followed. So there were various amendments made in 2002, and one of the amendment also was in Order 6 Rule 17, which says that no amendment to be made after trial has commenced unless the party pleads due diligence. So this is a provision which comes often, Order 6 Rule 17, and now very well settled principles of the Honorable Supreme Court and Honorable High Court on that. The next relevant provision is Order 7, which is with regard to the plaint. So plaint is generally the foundational document in a suit. So what should the plaint contain? That is mentioned in Order 7 Rule 1. It says that the plaint should contain various details. The most important details are that the plaint should contain a proper cause of action. It should contain whether the suit is, how the suit is within limitation. It should also contain a prior clause. It should contain how the court has jurisdiction, and certain additional details which are mentioned in Order 7 Rule 1 have to be mentioned in the plaint. The most important provision of Order 7 is Order 7 Rule 11. Why I say that this is most important? Because the large number of cases currently we have are under Order 7 Rule 11 CPC. What is Order 7 Rule 11? Order 7 Rule 11 says the circumstances in which the plaint can be rejected. So it contains provision with regard to rejection of plaint before the suit goes for a full-fledged trial. So it says, if I can just read it, it says the plaint shall be rejected in following cases. First is where it does not disclose a cause of action. The second is where the relief claimed is undervalued. The third is the next situation which may arise is that where the suit appears from the statement made in the plaint to be barred by law. So if a plaint is barred by law, it has to be rejected. And then there are other situations. The two most relevant situations here from the point of view of litigation are when the plaint does not disclose a cause of action, or when it appears from the statement made in the plaint barred by any law. So dear friends, if the from reading of the plaint, if no real cause of action is made out, then such a plaint has to be rejected under Order 7 Rule 11. Such a plaint need not go for trial. It is in fact the duty of the trial court to reject plaints under Order 7 Rule 11 if the plaint falls within the situations mentioned under Order 7 Rule 11. This power can be exercised even suo motu, that is, it has been held by the courts, or it can even be exercised on an application made by the defendant, because the defendant would make an application to reject the plaint. But there are certain principles to be kept in mind while exercising powers under Order 7 Rule 11. And few principles I will discuss very briefly. One is that while exercising powers under Order 7 Rule 11, the court has to only consider the documents of the plaintiff and the plaint. The documents of defendant and the averments in written statement, which is the reply, are not to be considered while exercising powers under Order 7 Rule 11. So only plaintiff's documents, averments in the plaint are to be considered while considering application under Order 7 Rule 11. If on the basis of averments of the plaint and documents of the plaintiff, the court comes to a conclusion that there is no cause of action for filing the suit, or that the suit is barred under any law, then the court would exercise powers under Order 7 Rule 11 and reject the plaint. So cause of action may arise, say for example, if father has sold the property and after 15 years the son wakes up and says that I had a right in that property, then it is not a meaningful cause of action. Then such it is a frivolous suit. Or barred by law means if you file a suit, I had given you an example with regard to civil court not having jurisdiction in particular cases. So if a defaulter files a suit that bank should not take action against him, even if he has defaulted, then such suits are barred under Securitization Act. If it falls under Securitization Act, then such plaints are required to be rejected. There are various laws under which civil suits are barred. So such suits are to be treated as suits barred by law. Limitation is also a law under which Order 7 to 11 powers can be exercised. So apparently on reading the plaint and the documents with the plaint, it is clear that the suit is barred by limitation. And on the ground of limitation also, the courts should in fact reject the plaints under Order 7 to 11 D. So whenever a plaint is rejected, it operates as a decree. It operates as a final judgment. And against that order, the aggrieved party has a right to file first appeal and thereafter second appeal. But if the plaint is not rejected, then that order, then there is no final judgment because the plaint is not rejected. So against that order, the aggrieved party will have a right to file a civil revision application before the High Court under section 115 of the Civil Procedure Code, which we just discussed above. So if the plaint is rejected, the remedy is to file first appeal. If the plaint is not rejected, the remedy is to file a civil revision application. So these are certain situations where the plaint can be rejected, plaint cannot be rejected. From the documents of the plaint, if the court feels that there is a mixed question of law and fact involved, I mean, if the question of limitation is not very clear from reading of the plaint, then the court will not exercise powers under Order 711. And the court would ordinarily say that this matter should be decided during trial. As I said earlier, only documents of plaint and plaint has to be seen. However, now, in view of certain recent judgments, the courts have taken a view that if it is a case of suppression, if foundational documents are not disclosed in the plaint or produced with the plaint, then the court can even consider those documents produced by the defendants and exercise powers under Order 7 Rule 11. However, this has to be done only in exceptional situation where there is a case of gross suppression by the plaintiff and fundamental documents or fundamental facts are not stated by him or produced by him. Only in such a situation, the documents of defendant can also be considered to ascertain whether there is suppression of fact or not. And if the court finds that there is a suppression which goes to the root of the matter, the court can exercise powers under Order 7 Rule 11 even by looking to the documents of defendants, but only in exceptional situation of gross suppression or suppression of foundational or fundamental documents by the plaintiff. Otherwise, the court would not have a power to reject the plaint by looking to the documents of the defendants. So, Order 7 Rule 11, in fact, is a very detailed chapter or provision. Large number of judgments are there. It can, in fact, consume whole session. But since we are only having an overview, I'm just giving you a bird's eye view of what the relevant aspects and features of Order 7 Rule 11 are. The next provision we come to is Order 8, which is written statement, set off, and counterclaim. So these are the provision with regard to the defendant's rights. The defendant obviously has a right to file written statement. The time limit within which written statement has to be filed is provided in Order 8. Only in case of commercial suits, that time limit is to be treated as mandatory. And beyond the time limit provided for filing written statement in commercial suits, the court will not have a power to condone delay in filing written statement. However, in ordinary suits, the time limit to file written statement is treated to be directory, and the court in a given case will have a power to extend that time limit if the defendant makes out a case that why he could not file written statement within the time limit provided. Also, in written, while filing the written statement, the defendant has to specifically deal with each and every averment and allegation of the plaintiff. A general denial is not sufficient. The defendant will have to specifically deal. The defendant obviously has to first give a general denial that I don't agree, I deny, and then he has to specifically say his facts also. He has to say why this averment of plaintiff is not correct. So evasive denial is not fulfilling the requirements of a proper written statement. Also, in cases where the defendant doesn't file written statement, the averments of the plaintiff would be treated as to be true. The plaintiff will still have to prove his own case. It is not as if just because the defendant does not file the written statement, automatically the plaintiff is entitled to a degree. However, if you do not file a written statement as a defendant, then the averment on facts of the plaintiff will be treated to be true, and the court will proceed on that basis. That is also specifically provided in Order 8. Then Order 8 Rule 6A deals with counterclaim by the defendant. So there may be cases where the plaintiff files a suit against the defendant, but the defendant may have a counterclaim against him. So if a plaintiff files a suit for recovery of say 50 lakh rupees, the defendants may say that the plaintiff is not entitled for recovery of 50 lakhs. In fact, I am entitled for recovery of 60 lakhs. So that is a counterclaim by the defendant. If the defendant says that the plaintiff has filed a suit for 50 lakhs, but I have already repaid him 10 lakhs, then he can also claim set off. He can say that from 50 lakhs, 10 lakhs are already paid, so only the claim remains for 40 lakhs, which also I am disputing. That is a set off which the defendant claims. So Order 8 deals with set off, Order 8 deals with counterclaim, and Order 8 deals with rights of the defendants to file a written statement. The next relevant provision, friends, is Order 9, Rule 13 of Civil Procedure Code. So Order 9, Rule 13 says that if a decree is passed in favor of the plaintiff, however, if it is an ex parte decree, then the defendant can apply to the court for setting aside of such an ex parte decree under Order 9, Rule 13 of Civil Procedure Code. So in some case where, say, the plaintiff files a suit, summons are served, nobody appears for the defendant, the court allows the suit of the plaintiff. So the defendant can, instead of filing first appeal, he can go to the same court and file an application under Order 9, Rule 13 and say that this summons was not served to me properly. I was not aware. I was prevented from sufficient cause from appearing, and therefore this decree, which is an ex parte decree, should be set aside only on this ground. And if the court finds that actually the summons was not properly served or the defendant was prevented from a sufficient cause from appearing in the matter, the court would exercise powers under Order 9, Rule 13 of Civil Procedure Code and set aside that ex parte decree, and the matter would then go for fresh adjudication on merits by part. So Order 9, Rule 13 is a relevant provision which is often used in cases where the defendant is not properly served or not duly served, or where he satisfies to the court that there was sufficient cause for his non-appearance. The next provision is Order 14, which is relevant. Order 14 deals with issues in a civil suit. So after the plaint is filed, the defendant files a written statement. The points on which the parties disagree in the plaint and written statement are the points of reference or the issues. So the court has to then frame issues in the matter. And the trial court, if you have seen any judgment of the trial court, will always find that issues are framed. Whether the plaintiff is able to prove this, whether the plaintiff is able to prove X, Y, Z, whether the defendant is able to prove. So while framing issues, sometimes the court also consider that on whose shoulders is the onus of proof or the burden of. So the issues are accordingly framed. Now, as you are aware, the provisions with regard to burden of proof are contained in Evidence Act Section 100 onwards. But that has to be kept in mind while framing issues. So if a plaintiff is asserting certain facts, then the issue has to be whether the plaintiff is able to prove this. If the defendant is asserting certain facts, then the issues would be whether the defendant is able to prove this. So the burden of proof has to be considered while framing issues. Also, issues are of two kinds: issues of fact and issues of law. So issues of fact would be issues where parties are uh, at on this are at variance with regard to certain facts. So that will be issues of fact. And issues of law would be whether, for example, whether the court has jurisdiction to try the suit or not. That will be an issue of law. In certain cases, limitation can be an issue of law. In certain cases, the issue of law would be whether if a suit is filed with regard to trust property, the issue can be whether permission of charity commissioner is taken or not. So that is also an issue of law. Issue of law would be whether in a given case where the court has not exercised powers under Order 7, Rule 11, but the court can still frame an issue of law whether the suit is maintainable or not, whether the suit is barred or not. So the thing is that in certain cases where certain facts are also to be seen, the court may frame an issue of law. Sometimes an issue of law can also be decided as a preliminary issue. Say, for example, an issue is framed whether the court has jurisdiction to try the suit or not, or whether the suit is barred by limitation or not, or whether the suit is maintainable or not. And such issues which they can be decided as preliminary issues, because if you decide that issue against the plaintiff, then there is no need to decide other issues. So if an issue of law is decided against the plaintiff, then the suit itself can be disposed of, and there is no need to decide other issues. So such issues can be decided as preliminary issues, uh, and therefore the other issues may not be required. Also, there is a provision under Order 14 which says that the issues can be amended also. So, for example, if issues are framed, either party can then apply to the court saying that, sir, in my submission, this issue is left out. It should be framed. So the court has a power to add issues. The court has a power to delete a issue. Also, in certain cases, even in first appeal, if the court feels that the trial court has not framed proper issues, the first appellate court can frame issue and send it back to the trial court for trying that particular issue. That power is available under Order 41. That power is with the first appellate court. So framing of issues is a very important function of the trial court. And the documents and pleadings, more particularly, have to be kept in mind or borne in mind while framing issues. The next relevant provision, if we go in sequence, is Order 21. This is a provision with regard to execution of decrees. The corresponding substantive provision is Section 47 of CPC. So Order 21 mentions the provisions as to how the decree can be executed. As I said, the general law is that the executing court cannot go beyond the decree. Order 21 Rule 26 and Order 21 Rule 29 deals with certain situation where the executing court can stay the execution of decree in certain situations. Say, for example, if a party is saying that I have to file an appeal, then and if the appellate court has granted stay, then the executing court will have to naturally stay the proceedings. And Order 21 Rule 29 says that if there is a subsequent suit between the decree holder and judgment debtor which is pending, then on satisfaction of the executing court that adjudication of that suit is necessary, the executing court can even stay the decree to await the outcome of that suit. There are further provisions as to how the property of judgment debtor has to be sold while executing the decree, how sale proclamation has to be made. There are also provisions, Order 21, Rule 89 and 90, which says that if the property of a judgment debtor is sold during execution of decree and the judgment debtor points out that the sale is fraudulent, then the executing court can set aside such a sale. Or if say if there is a money decree filed against the judgment debtor and the property is sold, but before the sale is confirmed, the judgment debtor deposits the entire amount. Even in such a situation, application can be made under Order 21 Rule 89 to set aside the sale of the property. Order 21 Rule 97 is another very important provision, an interesting provision. It says that while executing the decree, if a third party, but with regard to immovable property, if a third party obstructs execution of a decree claiming independent rights over that property, then the executing court will have to decide and adjudicate upon the application of a third party. Just to give an example of this situation, the plaintiff files a suit for immovable property for taking possession from the defendant. It is the case of plaintiff that defendant is illegally occupying that property and he gets a decree in his favor that the defendant should be evicted from the property. So when execution application is filed by the plaintiff and when the bailiff goes for executing the warrant of the court for possession, he finds that some third party is in possession. And third party says that it is in possession on the strength of some document like agreement to sale, etc. Then that third party's application obstructing the possession of the decree holder will have to be decided by the executing court. So those powers are available to the executing court under Order 27 Rule 97. And there is a very important provision. The executing court's important function would be to ascertain whether the third party is actually independently, bona fidely in possession of the property or it is set up by the defendant. That powers are with the executing court available under Order 21, Rule 97. The next relevant provision is Order 23 of Civil Procedure Code, which is with regard to withdrawal of suits or settlement in suits. So dear friends, in many cases you will find that the party does not want to continue with the suit. If a plaintiff who files a suit wants to unconditionally withdraw the suit, he always has the power to unconditionally withdraw the suit under Order 23 of Civil Procedure. The suit can always be unconditionally withdrawn. However, if the plaintiff is seeking a liberty to file a fresh suit, then that should not be given by the court unless the court is satisfied that there are circumstances in which such a liberty is required to be given. So the general rule is that unconditional withdrawal is the right of the plaintiff. The defendant can be obviously awarded cost. However, if the plaintiff wants to withdraw the suit with the liberty to file a fresh suit, then the court will have to be satisfied that there are circumstances in which such a liberty is required to be given. And only when the court gives him a permission to file a fresh suit, he can then file a fresh suit after withdrawing the earlier suit. Otherwise, if he withdraws an earlier suit unconditionally, then no fresh suit is maintainable. Very important provision in this order is Order 23, Rule 3, which is compromise of a suit. So it says that where it is proved to the satisfaction of the court that the suit has been compromised or settled by a lawful agreement which is signed by both the parties, then in such a situation, the court can pass a decree with in terms of the compromise. The compromise terms can also be beyond something which was originally paid for in the suit. Even that is a valid compromise. The only fetter on the power of the court is that the court has to see whether that compromise is lawful or not. So parties cannot enter into an illegal compromise which is against public policy. For example, if there is a suit with regard to a land and the land is a restricted tenure of land, then parties by compromise decree cannot say that okay, the plaintiff will sell this land to the defendant because government's permission is required before you sell such a land. So a compromise which is contrary to law will not be permitted by the court. Otherwise, if it is not contrary to law, the parties are free to settle the matter and the compromise decree can accordingly be passed even if the terms of compromise are beyond the original suit. Now, what happens if there is a compromise decree? The parties have submitted compromise to the court, but then one party says that this compromise is illegal, I was misled. In such a situation, the view taken is that if a party is signatory to the compromise decree, then such party cannot then file an appeal against that compromise decree. The only remedy available to that party is to approach the same court and say that, sir, this compromise decree was passed, though I have signed, I was misled, there was force, coercion, etc. Please recall that compromise decree. Order 23, Rule 3A also says that separate suit is not maintainable to set aside compromise decree on the ground that the compromise was not lawful. So meaning thereby, if you sign a compromise decree, you cannot then take a view or stand that this is an unlawful decree. The only remedy available to such a party who is actually aggrieved by the compromise decree is to approach the same court. So that is as far as Order 23 is concerned, which is also used often in day-to-day trials. Next is Order 26, Rule 9, which is powers of the court to issue commissions. So many times you would have come across situations where you see that a court commissioner is appointed. So that power is available to the court under Order 26, Rule 9. The court commissioner is normally appointed to ascertain or assist the court with regard to the actual position of the suit property. However, it cannot be appointed for collecting evidence on behalf of either parties. So sometimes parties to the suit are very smart. They may not have any independent evidence, but they may approach the court saying that please appoint a court commissioner. That is, sometimes they want to do it as a tool to create an evidence in the court in their favor. So the law is that if a person is making an application for appointment of court commissioner to create evidence, then that application cannot be entertained. However, court commissioner can always be appointed if the court feels that such local inspection is necessary to enable the court to ascertain the correct position of the or situation of the suit property. So, for example, if there are disputes with regard to boundaries of some land, sometimes court commissioners are appointed to know what is the exact area of the land. Sometimes experts are appointed as court commissioner, like DILR can be appointed as a court commissioner for measurement of land. So it is ultimately for the court concerned to see whether the court needs the help of court commissioner or not. So that is Order 26, Rule 9. The next relevant provision is Order 37 of CPC, which is with regard to summary suits. So summary suit is a different kind of suit, which is slightly different from the other suits. It is a separate code in itself. The courts have taken a view that Order 37 is a separate code in itself. It deals into what situation a summary suit can be filed by the plaintiff. So normally a suit which is based on a written contract or a suit which is based on a bill of exchange like check, etc. For such suits, summary suits are filed. The difference is that in summary suit, the defendant cannot automatically defend the suit. He has to first file a leave to defend application. If the court is satisfied that his defense is genuine, the court may give him an unconditional leave to defend the suit, and then the summary suit would be tried as an ordinary long cause suit. But if the court finds that the defense of the defendant is not very satisfactory, the court may even impose a condition upon him to deposit certain amount before the defendant is entitled to defend the suit. So, for example, if the defendant has given a check of say 1 lakh rupees to the plaintiff and the check is dishonored, the plaintiff goes to the court and files a summary suit for recovery of 1 lakh rupees because that suit is based on the basis of a check which is dishonored, so he can file a summary suit. In that, the defendant will not be permitted to defend the suit automatically. He has to point out certain circumstances in which he is entitled for a leave to defend, and the court can do three things. The court can give him an unconditional leave to defend. The court can say that all right, you defend this suit, but first you deposit the amount of the check or at least 50% of the amount. And in some cases, if the court is satisfied that the defense of the defendant is completely frivolous, the court can even refuse leave to defend. In that case, the plaintiff would thereafter be entitled for a decree. So these are the situations in which summary suits are filed. One important provision in Order 37 is Order 37 Rule 4, which is similar to Order 9 Rule 13 of CPC, but with some difference. So if you recollect, we have seen Order 9 Rule 13 is a power to set aside ex parte decree. Order 37 Rule 4 is a power to set aside ex parte decree in a summary suit. The only difference is that in Order 37 Rule 4, the defendant will have to show special circumstances in which he could not defend the suit, and thus why the suit was ex parte. So special circumstances will have to be pleaded and proved by the defendant in order to have a decree in summary suit set aside. Also, while setting aside summary ex parte decree in a summary suit, the court may consider whether such a defendant was actually entitled for a leave to defend or not. If the court is satisfied with such special circumstances, the court may set aside a decree in summary suit and may grant leave to defend to the defendant. Otherwise, the court will not set aside a ex parte decree in summary suit just on asking. So that this is the slight distinction between Order 37 Rule 4, that is ex parte decrees in summary suits, and Order 9 Rule 13, that is ex parte decrees in ordinary suit. The next provision which is very important is Order 39. So Order 39 is the most used provision in CPC. It is a provision with regard to grant of temporary injunctions or interlocutory orders. So as you know, if the plaintiff files a suit, during the pendency of suit, he can file an application seeking injunction. Injunction can be like the defendant should be restrained from transferring the property, the defendants be restrained from construction over the property, the defendants be restrained from evicting the plaintiff. In case of money suits, sometimes people ask for injunction that the defendants be directed to deposit the amount in court. So there are various cases in which injunction applications can be filed. In order to pass an order of injunction in favor of plaintiff, the court has to consider three things. The first is the court has to consider whether the plaintiff has a prima facie case or not. That is the first thing. The second, the court has to consider whether balance of convenience is in favor of the plaintiff or not. And the third is the court has to consider whether irreparable harm and injury would be caused to the plaintiff or not by refusing to grant injunction. All these three things have to be satisfied, and all these three things have to operate in favor of plaintiff for the court to grant an order of injunction in favor of the plaintiff. It is not enough if the plaintiff says that I have a prima facie case in my favor, but the balance of convenience is not in my favor, then he will not be entitled for injunction. The plaintiff has to satisfy the court that he not only has a prima facie case, even the balance of convenience is in his favor, and irreparable harm and injury would be caused to him by not granting of injunction. In certain circumstances, the court can even grant an ex parte injunction. But if the court grants an ex parte order of injunction, the court should try and dispose of the injunction application within 30 days, provided in the court. Order 39 Rule 4 says that in circumstances, the order of injunction can even be modified. So once if the court has granted injunction after hearing both sides, and there is a subsequent change in circumstances, the affected party can apply to the court for modifying the order of injunction. That provision is Order 39, Rule 4 of Civil Procedure Code. So you will come across various cases, case laws of Honorable Supreme Court and Honorable High Court as to when injunction can be given, when injunction cannot be given. Ordinarily, if damages are sufficient to compensate the plaintiff, order of injunction would not be given. Certain principles of specific relief act also have to be considered in cases of injunction pertaining to immovable property. So these are the broad factors while with regard to grant and power of injunction. The next two provisions which I would like to briefly discuss are Order 41 and Order 43 of Civil Procedure. So Order 41 of Civil Procedure Code deals with the power of the appellate court. The corresponding section is section 96 of Civil Procedure Code, and Order 41 contains the procedure which the first appellate court should bear in mind while deciding the first appeal. Relevant in that are Order 41 Rule 5, which is the power of the appellate court to grant stay. So the appellate court can stay the order of the trial court under Order 41 Rule 5. However, if it is a money decree, then ordinarily the appellate court would ask the appellant to deposit the entire amount before granting stay against execution of money decree. Or if the appellant is able to make out a case that the decree itself is fraudulent, etc., in rare cases, unconditional stay of money decree can also be given. So that is a relevant provision, Order 41 Rule 5. Another relevant provision in this is Order 41 Rule 27. So what is Order 41 Rule 27? It says that even before the appellate court, the party can produce additional evidence. So normally the rule is that the evidence has to be produced before the trial court. Once the trial is over, the appellate court can reappreciate whatever evidence is produced. However, Order 41 Rule 27 says that even before the appellate court, you can produce additional evidence if you satisfy the requirements of Order 41 Rule 27. So the requirements are that you have to show that despite sufficient care, you could not produce that evidence before the trial court, and that evidence is very vital for adjudication of the dispute. And if you are able to satisfy the conditions mentioned in Order 41 Rule 27, then the appellate court can allow production of additional evidence even at the appellate stage. And the last provision which I wanted to briefly discuss is Order 43, which says in what cases appeal from orders can be filed. So in certain cases, appeal from orders are filed before the district court considering the valuation of the property of the suit property, and in certain cases, appeal from orders would lie before the High Court. Currently, if the valuation of suit property is below 50 lakhs, the appeal from order would lie before the district court. If it is above 50 lakhs, the appeal from order lies before the High Court as per the current regime. Also, Order 43 contains the orders against which appeal from orders are filed. So appeal from orders are basically appeals against interim orders or appeals against orders mentioned in categories under Order 43. So against final order, there is a provision of first appeal. But against interim orders or against orders passed, say for example under Order 9 Rule 13, an order rejecting the application, appeal can be filed under order 43. So if injunction application is dismissed, appeal can be filed under order 43. The Honorable Supreme Court, in a very landmark judgment of Wander versus Antox, has said that this interlocutory appeal under order 43, the court would have limited power, and just because a different view is possible, the court would not upset the findings or the orders of the trial court. However, if the court finds that an error of law or error of jurisdiction is made, the court can certainly set aside the order of the trial. So order, that is as far as order 43 of CPC is concerned. Now, one important judgment which you should all also, I would suggest reading, is the judgment of Salem Advocate Bar Association versus Union of India, which is reported in 2005, volume 6 SCC, page 344. That judgment deals to various situations of CPC after the amendment of 2002. So in 2002, there were certain amendments made in Civil Procedure Code, and those were challenged before the Supreme Court, saying that these amendments are ultra virus, violative of other provisions, etc., etc. And the Honorable Supreme Court has, in Salem Bar Advocate Association, laid down as to what kind of provisions of CPC are directory, what kind of which provisions are mandatory, in what cases cost should be imposed. There is a provision of section 80 notice in Civil Procedure Code which says that if you file a suit against, say for example, government, then you have to give a 2 months notice to them before filing of the suit. That has been interpreted by the Honorable Supreme Court. The Honorable Supreme Court has also said that right to expeditious trial is part of Article 21 of the Constitution of India, which is akin to right to life. So it is a very landmark judgment of the Honorable Supreme Court, and I suggest reading of that judgment to everybody. So this is in nutshell a brief overview of some provisions of Civil Procedure Code. While I understand that hurriedly we had to go through it because of the paucity of time, otherwise to understand each provision of CPC may require one session each actually. And last 3-4 minutes, I thought that if anybody has any questions, we can even take them and discuss. So
Uh, Thank you so much, sir. Now we open the floor for question and answers. Anybody have any questions? You can raise your hands or write your question in the chat box. So there's one question in the chat box. If the suit is dismissed for default by the court can restore the suit in provision in section 144 of CPC?
no. If the suit is dismissed for default, then the power for restoration is under Order 9 of CPC. 144 is for restitution. It is a case to restore the position if the order is reversed. Dismiss for default, the party will have to file a restoration application to restore the suit. That is contained in Order 9 of CPC.
So next question is, what is difference and similarity between money suit and summary suit? Can we file summary suit instead of complaint under section 138, Negotiable Instrument Act?
Okay, so summary suit can be filed in cases falling within the category mentioned in Order 37. So if, for example, a check is dishonored, you can certainly file a summary suit because it is a bill of exchange and falling in the category of Order 37. However, filing of summary suit doesn't mean that you should not file a complaint under Section 138. That is a completely independent provision. That is a penal provision, criminal action. So a party can always file a summary suit and a complaint under 138 simultaneously. Both operate in different fields. Now, as far as money suits are concerned, if the money suit is falling in the category of cases mentioned under Order 37, a money suit can be filed. But if the money suit is not based on any written contract or is not based on any bill of exchange, then you have to file a simple civil suit for recovery. Otherwise, you can file a money suit under Order 37, summary suit, that is, if it is falling in categories mentioned in Order 37.
Sir, next question is what is the fundamental difference between interim order and interlocutory orders?
So that you will find that discussion with regard to judgments given in section 115 of Civil Procedure Code, because uh, see, interim orders are orders which do not finally decide rights of the parties. So are interlocutory orders. But certain interlocutory orders may have the effect of even disposing of or finally deciding the proceedings. Like if you take an example, that injunction application is an interim order, but maybe order 7 or 11 order is an interlocutory order. So interlocutory order and interim order as such can be used interchangeably. But you will find some discussion when you read the case laws with regard to amendment made in section 115 of CPC.
Uh, Sir, if trust filing suit against its tenant, is the trust need to take permission of commissioner to file such suit?
No, but you should see the provisions of CPC. I think it is just order 31, 32. The and the provisions of the Trust Act. Actually, the question pertains more to the provisions of the Trust Act than overview of CPC. But if the trust has to file a suit against tenant, it does not have to take permission of charity commissioner. When permission of charity commissioner has to be taken is mentioned in section 50 of the Gujarat Public Trust Act. So if the beneficiaries of the trust want to file a suit, they will have to take permission of charity commissioner. If you want to file a suit against the trust, you will have to take permission of charity commissioner. So I would suggest the participant to please go through provisions of section 50 of the Gujarat Public Trust Act.
Sir, one last question. In which condition leave to defend may allow? Any citation is there for allowing leave to defend?
Yes, there are many judgments. So the general principle is that if there is a triable issue involved, if the defendant is able to make out a triable defense, then leave to defend should ordinarily be allowed and unconditional leave to defend should be given. However, if the defense of the defendant is completely moonshine or bogus or frivolous, then unconditional leave to defend may not be given. A conditional defend may be given, or in some cases, leave to defend may even be refused if the defense is completely frivolous. So the court, while examining leave to defend application, will have to apply its mind whether the defense made out is bona fide, genuine, raises a serious tribal issue or not, and considering that, the court may decide to grant unconditional leave to defend, or the court may decide to grant conditional leave to defend, or the court may refuse to grant leave to defend. These are the principles to be kept.
Uh, Thank you so much, sir, for answering the questions and for this wonderful session.
I would like to
On
thank. I would also like to thank Sambhav Initiative for giving this opportunity to me, and I hope, being Sunday morning, the participants were not bored. Session.
Thank you, sir. On behalf of organizing committee, I extend my deepest gratitude to you, sir, not only for accepting our invitation, but also for this wonderful session. And I would also like to express my deepest gratitude towards Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, under whose vision and guidance we were able to conduct this session on 10 days online national capacity building program for civil judge examination of Gujarat State Judiciary. And thank you all the participants for joining us today. Thank you so much, sir, for this wonderful session.
Thank you very much, and all the best to everybody.